All right, looks like I'm live. And in case you didn't know, in case you didn't see it live, we just had the oral arguments here this afternoon in the Walker versus Donahoe case, which is the AR-15 open carry case, sometimes called the AR-15 open carry, you know what, sucker case. If you haven't watched the video, you can look in the description and there's a link to the video, the underlying video that was in dispute in the case. Today, again, we had the oral arguments in that case before the Fourth Circuit. If you missed it live, also in the description of this video, I believe I properly linked the recorded audio from, even though it's on YouTube, from the court's website. It was streamed live, and I believe it's there indefinitely. So I obviously just finished and sort of stripped off my at least the top half of my suit. They wouldn't know that you were wearing underwear or not wearing underwear underneath. In fact, the way that we did it here is I actually had my staff put the phone on, take the phone off the hook, and they all came in to watch because they were super interested in it. And this was the first time that I did a remote appearance before a U.S. Court of Appeals. Last time I did it was in person at Richmond. I just appeared at the West Virginia Supreme Court here a couple of weeks ago. Well, yeah, a couple of weeks ago, and that was in person. So this was my first time trying that, and I'm really not an appellate lawyer. I'm a trial lawyer with jurors, with juries and questioning witnesses and all that. So this, appellate litigation is a completely different thing that I've never really done a whole lot of, but I'm the sort of person who likes to be in the courtroom. And that's part of it is getting yourself pumped up and being there in the moment. And it's kind of hard to do that just sitting right here, where I'm sitting now. So that was kind of a weird thing, but actually having my people in here watching was sort of like having a crowd watching, got me in a little better position probably. And also Helga, the German Shepherd, the office security dog, was also watching. But basically, if you're unfamiliar with the case, it's what I think is an important gun rights case in the Fourth Circuit. And the Fourth Circuit is West Virginia, Maryland, Virginia, North Carolina, and South Carolina. It's one of the federal circuits, and really the only court above that is the U.S. Supreme Court. So this was a case from Putnam County, West Virginia. And this is the case where my client, Michael, was walking down the side of the road with an AR-15 style rifle strapped to his back, safely, non-threateningly, was on his way coyote hunting. And there was some sort of Karen call. And this really polite deputy gets called to, shows up at the scene, doesn't know what the 911 call was about, doesn't know who the 911 caller was. And he just wants to basically stop and ID him. Michael knew his rights, that was illegal unless he had asked, what crime have I committed? What crime am I suspected of committing? And the officer basically said, when I tell you, give me your ID, you give me your ID. It was that sort of thing. So it kind of went downhill from there. We sued. So this is a civil case, Section 1983 case, rather than a criminal case. So eventually he was let go, and the whole thing lasted like 8 minutes. And it was a really obscene, vulgar encounter. Like I said, he was called a you-know-what sucker 3 times. And I don't mind saying it, but YouTube probably puts me on another one of their lists if I say it. So he was let go. And basically once defense lawyers got involved, they knew it was illegal, so they had to come up with some sort of way. They did some legal gymnastics. And after we sued them for what was clearly a violation, clearly illegal, after we sued them through the lawyers, they came up with this defense. Well, there was a school about a mile down the road. So he was heading in the direction of a school. And therefore, I was concerned about this being a copycat of the Parkland shooter because he had an AR-15. He was headed in the direction of a school, and it was in close proximity to the Parkland shooting about a month later. Now, if you watch the video, the whole thing's captured on video. There's no mention of a school. In fact, you hear crickets in the video. That's because this happened at dusk. He was headed coyote hunting. So it was clearly illegal. He came up with this BS excuse about he was worried he might be a copycat shooter out to shoot up a school, murder innocent children. But you can watch the video one time and see that that's total BS. He didn't say anything, bring up anything about a school. In fact, the officer admitted that after letting him go, he didn't even follow him to see if he was going to murder children or ask anyone else to do so. Didn't contact the school, nothing like that. The school had nothing to do with it. And this is an objective standard by the court after the fact. So they, sort of tried to use that against us. But basically what happened, it was a very straightforward civil rights lawsuit. You're not allowed to stop and perform an investigatory detention of somebody just because they have a firearm in West Virginia. So he was openly carrying a firearm. Well, that's legal in West Virginia. He was in possession of an AR-15 style rifle. That's legal in West Virginia. So there's actually a case from 2013, really maybe the only good gun rights case, one of them left in the Fourth Circuit, called United States versus Black. And if you watch the video, you see where I bring up Black. And Black is directly on point with this issue. All police officer needs reasonable suspicion to perform an investigatory stop of somebody. We're talking about a pedestrian, not talking about a vehicle stop, because that is based on not having the blinker on or speeding or not stopping at a stop sign or whatever. This is with a pedestrian. So you can't just stop a pedestrian in West Virginia because they're open carrying a firearm. Why? Because open carry is legal in West Virginia. And AR-15s are legal in West Virginia. And so it's also legal in North Carolina. So there was a 2013 case out of North Carolina, U.S. versus Black, that says, well, you can't harass this black guy in a high crime neighborhood just because he is with somebody who has a gun, because North Carolina has bestowed upon its peasants the ability to possess a gun and to open carry a gun. So in an open carry state like North Carolina, you cannot just use the presence of a firearm on a pedestrian without knowing something more as a basis to stop and get their ID and run their background check. Because unless you know that person is a convicted felon or you suspect they've committed some crime other than just firearm possession, because that's legal, you can't do that. So our case was directly that. In fact, if you watch the video, Deputy Donahoe says, he argues with Michael about it. I can stop you and demand your ID. In fact, I do it all the time. Every person I see with a gun, I stop them and I get their ID. And that's clearly in violation of United States versus Black. But they had to come up with something, so they came up with this well, he could have been heading towards a school. So despite the fact that it was like dusk and the school was closed and there was no mention of a school, and he clearly wasn't concerned about a school. And in fact, there's actually a sheriff's department detachment or whatever you want to call it right next to this school. So there was no basis in the record, but they latched onto it just to attack gun rights. And in fact, this county that's been litigating this against us was the first county in West Virginia to declare themselves to be a so-called Second Amendment sanctuary. So that's what kind of a joke that is. It all started with the arguments and their briefing materials down at the trial court. They started calling the AR-15 basically the scary black rifle and the weapon of mass murder. And since they saw him with an AR-15, he couldn't have been using it for any lawful purpose because they're not used for hunting, blah, 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 blah. And unfortunately, the court ran with that. It had nothing to do with the case, but it was just an attack on the AR-15. Well, yeah, any regular firearm that somebody's possessing, yeah, U.S. versus Black would apply. But since this was an AR-15, then he might be a mass murderer, so he can be stopped and ID'd and apparently called a you-know-what sucker 3 times. So that's what happened. We appealed the trial court ruling to the Fourth Circuit. We briefed it at the Fourth Circuit, and then it was accepted for oral arguments. And that's unusual. They usually only do that in fairly important cases. And, you know, I thought that they sort of made this, unfortunately, into an important case, because if they win, it could just completely overrule our last good gun rights case in the Fourth Circuit, which is U.S. versus Black. And they already limited it in 2017 in a case called U.S. versus Robinson. And U.S. versus Robinson was an en banc case in the Fourth Circuit, which means it was all the judges sitting there rather than a 3-judge panel. And they basically found that U.S. versus Black didn't apply to the occupants of a lawfully stopped vehicle. So if you're in a traffic stop, even if you're a passenger in a car and you're not alleged or suspected of having committed any crime, just by virtue of the fact that the officer sees that you're armed, you're considered armed and therefore dangerous, and you can be disarmed during the traffic stop, and then they can run your background check and all that. And that's unfortunate. And the author of United States versus Black, Judge Gregory, issued a very good dissenting opinion in U.S. versus Robinson. And a lot of it has to do with civil rights. You know, if you can argue, if police can just speculate that somebody's might be a criminal because they're in a quote high crime neighborhood, or they're a black guy with a gun. I mean, you're allowing those sorts of decisions to be made. And in fact, ironically, what's happened here is the Fourth Circuit has taken the position in the Black case that, well, we have to protect these, you know, inhabitants of Black neighborhoods, because we can't allow police just to speculate that they must be a felon in possession of a firearm because they're in a high crime area. But yet they're doing the same thing in this case, the opposite thing, that, well, here we have a white guy, Michael Walker, in a suburban area. And, you know, the same protections don't apply because of, you know, based on what? The color of his skin? I don't know. So it should be very simple. You can't stop and forcibly ID somebody based on their mere possession of a firearm if you're in an open carry state where that's legal, unless you have some actual information about that individual is a felon or you know, fits the description of some guy who just robbed a bank like 10 minutes ago. I mean, there has to be something there. You can't just say, like this officer actually did in this case, well, I stop everybody with a firearm and run all their IDs just to see if they're a felon. If they're not, I send them on their way. That's what he did. That's what he admitted to doing. And that's illegal. So that's when they did the legal gymnastics and turned it into potential, they're just concerned about the school down the road. And again, that's complete BS. So we had the arguments today, and they picked the panel this morning. So the panel is just 3 judges out of the 8 or 9 or 10 or whatever, however many judges there are in the Fourth Circuit. They picked the 3, don't disclose them till the morning of. So I got an email with the judges' identities, and I don't think I had appeared before any of them before. One was a fairly recent Trump appointee, Judge Richardson, who just happened to be, I think, the federal prosecutor who prosecuted Dylan Roof from the Charleston church shooting case. So I didn't know whether that was going to be beneficial to me or a bad thing, but it seemed kind of a coincidence. The other 2 judges, Judge King, who actually lives in West Virginia, not far from me, been on the bench a long time, very well respected, and Judge Keenan was also, and so I this morning I looked up there, tried to read every similar decision I could that they had issued in the past, and some of them were in some similar cases, but not directly on U.S. versus Black or a very, very similar case, really. So we had the oral arguments just a little while ago, and from 2:00 when they started, I just sort of had to sit there and watch the other cases in front of me. And if you watch it, there was a bump stock case, but I knew from listening to the bump stock case that there was going to be similar stuff coming my way when it got to my case, because there was all this talk about, well, does a bump stock create a machine gun? I mean, and just all sorts of stuff like that. And that's sort of the way it went when we had oral arguments is, I go first. We each had 20 minutes in these things. So I get to apportion my 20 minutes to save some for rebuttal. So as the appellant, the person appealing, you get to go first and last. So but you don't get additional time. So you save some of your time. And I think the other lawyers today did the same thing I did. So I reserved 5 minutes for rebuttal and then cut it down to 15 minutes for my beginning. And ended up, I think, going over on both accounts because they were really questioning me. But what kind of the story of the day is that, as I suspected, it all just became about the AR-15. It had nothing to do with it. In the actual facts of the case, the entire incident was recorded, had nothing to do with it. For instance, I was asked, and you can listen to this, but I was asked, should the officer, wasn't he justified in just assuming that this was a machine gun? Because it looks just like a machine gun. So we'd have to actually take it and examine it to see if it had the switch went all the way to rock and roll. And so I sort of had to say, well, Judge, this is, the AR-15s or style rifles are, the most popular and widely owned sort of firearm in the United States at this point. I think there's 2.1 million people that have them. They're commonly used for hunting at this point. And even though if judges may not understand that, and no, there's no basis for assuming that this was a fully automatic machine gun, and that even, some people can possess fully automatic machine guns if they've paid, for the tax stamp and all that. So, but it had nothing to do with the case. But I just kept getting peppered with those sorts of questions. And there was discussion about camouflage pants, about sleeveless shirts, and, it just stuff that should not be discussed in the context of discussing the Fourth Amendment. You get to exercise the Fourth Amendment unless you are wearing camo pants, or unless you have a black sleeveless shirt, or unless you have a certain sort of firearm, even though it's legal as per your state legislature. So what the police were asking for here, what the court's looking at doing, is basically legislating from the bench. Now, they're not allowed to do that because we have a case already on point, United States versus Black. And that was a panel decision, so meaning 3 judges rather than all of them. Now, the rules state that another panel can't overrule the binding precedent of a prior panel. It would take the court sitting en banc, the full court together, to do that. But that, this was not sitting en banc, so they can't do that. Now, one possible way around this, if they want to rule against us, they could just say, well, we find that there should be a grant of qualified immunity, good old qualified immunity, because it's not, and the defendant actually argued this, because this is a Section 1983 case, a civil lawsuit, rather than a criminal case. You don't even necessarily have to decide this case. You could just say, yeah, well, it's such a gray area. It's so kind of close that we should give qualified immunity. And maybe that's what they do, and that happens all the time. And it's usually search and seizure cases where they give qualified immunity. So hopefully that doesn't happen. But that probably, I guess, would be a better result than them saying that, all right, AR-15s are the weapon of mass murder from this point forward in the Fourth Circuit, and police can stop you if you have them, and just make sure that you're not a mass murderer. So looks like we have somebody a guest who watched it live. I'll see if I can bring you up pretty easily here and get your thoughts on it. Hi, is this RoboCop? Are you there? Is this Mr. Ziegenbach? Can you hear me?
Yeah, Ziegenbach, can you hear
Okay.
me?
Yeah, I hear you. I
Yeah.
got you on here. Did you watch?
I just got done with the recording. Yeah, great job. They really came after you. That kind of sucked. One thing I noticed, and please take this as being, respectful. You did a great job. You didn't bring up that your client was handicapped and he had to walk. And if they were going to, I mean, the way they were peppering you, if they were actually going to rule that way, which it sounds like they're going to, he has no Fourth or Second Amendment rights, or at least all handicaps don't, because the guy can't drive somewhere, and that's the only way he could have carried his AR-15 was in the open. But other than that, man, you did a fantastic job. But the panel didn't sound favorable to you.
I mean, it came up below. I mean, we litigated the heck out of it at the trial court level, and I don't recall whether that was mentioned in the briefing or not. I think it was. I think unfortunately it seemed like that maybe they hadn't even read the briefs yet, but it was mentioned in the briefing as was the the whole time of day thing, because this officer testified at his deposition under oath that this happened while school was in session. And then we find out afterwards, still at the lower court, that it actually happened after 6:00 p.m. In fact, then you listen, you're like, oh yeah, I can hear the crickets. And I did some research on that. And yeah, crickets only come out at dusk. And so that was mentioned in the briefing. We didn't really get to it in oral arguments. But part of the problem is that it's just not enough time. You can't get to everything. But
yeah, they were taking you off course there. Probably doing that on purpose. I don't think you're going to get a favorable ruling out of them, but
yeah, I think they might go for the qualified immunity. So they'll just punt it, say, well, we're allowed to not decide this if we think that the facts are sufficient to establish qualified immunity. And here's the other thing is they're making factual determinations. So the whole argument that he looks young, that had nothing to do with it. The argument that he looks young, that's so you're looking at the video, seeing a guy with a beard, and you're thinking that he might be under the age of 18 and therefore unable to possess a firearm in West Virginia. Mm-hmm. So and there are exceptions to that, but that's what a jury, that's a factual determination for a jury. And
yeah, or it could have had a bump stock on it. That was hilarious when he brought that up. You're right, though. It's perfectly legal to open carry in a variety of states, NFA weapons. So, yeah, if you had some more time, maybe to hit on a couple of those topics, might have made a difference. But I think unfortunately your client isn't going to win this one.
Yeah, the other thing I wanted to bring up, I had written down, I just didn't have time, is, for instance, when they brought up, when one of the judges brought up, well, isn't an AR-15 isn't a military weapon, et cetera, et cetera. Well, the Ninth Circuit and the Duncan case, which still kind of out in limbo, had a really great opinion, which I cited in my brief in this case because it came out the same day I filed the brief. But it had the whole explanation of the history of firearms in America and how all of our firearm possession as Americans have always been based around the adaptation of military weapons to our lives as Americans. And so that has nothing to do with it. That's just par for the course for America. And I didn't get a chance to bring that up because there just wasn't enough time, and they didn't give me a whole lot of time to work with to run because they kept asking me questions.
Yeah, well, I'll leave you with this. I'm not familiar with this app or whatever, but your picture on this is fantastic compared to like some of your YouTube channels. So this is great if you're going to use this form going forward. This is great.
Oh, well, thanks. This is Streamlab, and there's StreamYard. And I actually got the idea to referred to StreamYard by a guy you might know as Nolo. That's what he
Okay.
uses. And I've been trying to get him to come on for a while, but he's been busy, and he was involved in the Duncan case. And Nolo, if you're listening, come on. But yeah, this is just. I had to pay extra to be able to get 1080. But the problem is that my internet sucks. At this particular office, sometimes it's hit or miss. I was actually worried it might cut out or go unstable during the arguments, and you couldn't see it from the YouTube link. I don't know why they don't show because it's a Zoom hearing is all it is.
Mm-hmm.
They didn't show it. But anyways, I appreciate the insight that sort of reflects kind of how I thought about it. Once I finished and sort of had a cup of coffee thinking about it.
Well, thanks again. I appreciate it. I'll go ahead and mute.
Yeah, appreciate it. And if any other of you watched, utilizing this technology, I could actually bring you on for a comment if you have, like a Zoom sort of capability. I'll put the link in here, and I think it'll allow maybe up to 10 people at a time. If any of you look fairly awesome, maybe I'll bring you in. All right. If you check the comments, it should be in there. So that's the link. If you have anything nice to say, anyways, let's see. But yeah, that was a good summary of basically how it happened. And, I had a response to pretty much everything that was brought up, and it's frustrating because you're sitting there just forced to listen while the other guy's talking, and you're like, you have a response and you want to throw it out there, but you can't. You especially can't in this context. Maybe at the trial court level or something like that, sometimes you can interrupt with something like that's total BS, but you can't do that before a U.S. Court of Appeals. I mean, it's in real life. The only other time I've done it, it's like super, super formal. They come out and they used to shake your hand. I'm sure that'll never happen again. Introduce themselves to you. It's very respectful process. Very, very formal process. But here, it's like everything is a Zoom hearing now, and it's frankly a bizarre world that we're in. Let's see. I'll look at some of the questions here. I appreciate you guys being interested in this. I know some people have been following this from the beginning, but let's see. OKC Vet, appreciate that. Andre, thanks for the comment. See, Hiram, Judge King is the author of the Weapon of War case, from what I remember. Yeah, I don't think I've appeared before him before. The problem is a lot of these judges have a reputation of being pretty progressive / liberal on civil rights cases or police cases. Like, they won't hesitate to hold the police accountable, to deny qualified immunity. But then you add in the aspect of it being a gun case or gun rights case or firearms related case, and it's like everything's out the window, and you get all sorts of extraneous, irrelevant information inserted into the case. It's not just this, but others. I mean, why are we discussing the origin or use of the AR-15 or the AR-15 style rifle? In West Virginia, it's legal to own, it's legal to possess, legal to open carry. What business is it of any court, whether state or federal, to contradict the judgment and legislation of the West Virginia legislature? So that's like saying, and this was, if you look at the dissent from Judge Gregory in the Robinson case from 2017, he brings this up and he says, West Virginia. Well, let me read it. I think it's here somewhere. Oh, I had it somewhere. All right. All right. West Virginia has taken a different approach, permitting concealed carry without the need for disclosure or temporary disarmament during traffic stops. And this did come up during the hearing. You know, I think opposing counsel and one of the judges tried to say that, well, you can be required to show your ID in West Virginia. And so I had to point out, and I did point out I think I did, that's actually not, well, man, maybe I didn't even get to that. I had written down, and this was in my brief, that no, West Virginia is not a stop and ID state, that they cannot, force you. The police can come up and engage in a consensual encounter. They can ask you questions just like anybody can, but they can't require you or force you to give them an ID without some additional facts. So they couldn't have forced him to give an ID in this case without some additional facts. Now, there are some situations in West Virginia where you can be forced to give an ID. And then if you don't, you violate the obstruction statute. But that requires some specific reason why it's more complicated, why they need to see your ID. And where they're getting this from is a case from the Fourth Circuit called Heibel that says that, failure to give ID where it's required can form the basis of reasonable suspicion. But we're not there. We're not in the Sixth Circuit. We're in West Virginia in the Fourth Circuit, and we have to go back to the U.S. versus Black holding that says you can't be harassed like this just for possessing a gun. Because if you can do that, then you can discriminate against people in high crime neighborhoods. Cops can do what we're all over the country we're saying that they do. But ironically, we don't get that same application of logic towards Michael Walker. So in Putnam County, West Virginia. So that's unfortunate. So back to this quote here, but this is Judge Gregory's words, and he's on the Fourth Circuit. Too bad he wasn't on the panel. But he said, for the reasons I described above, I do not believe we may deem inherently dangerous any West Virginia citizen stopped for a routine traffic violation on the sole ground that he's thought to avail himself fully of those state law rights to gun possession. He said, I recognize the expanded rights to openly carry or conceal guns in public will engender genuine safety concerns on the part of police officers, as well as other citizens who may often find themselves confronting individuals who may be armed. But where a sovereign state has made the judgment that its citizens can safely arm themselves in public, I do not believe that we may presume that public gun possession gives rise to a reasonable suspicion of dangerousness, no matter what the neighborhood. And because the rest of the circumstances surrounding this otherwise unremarkable traffic stop do not add appreciably to the reasonable suspicion calculus, I must conclude that the police were without the authority to frisk Robinson under the Terry's armed and dangerous standard. So in that case, again, that issue is can police frisk just anybody in a car just because they're armed? Because it used to be under Terry frisks, Terry searches, Terry versus Ohio, the worst set of case law for citizens that ever came out of the Supreme Court. Police, if you're armed and dangerous, then they could frisk you. So then the question was, well, the allegation was, well, if you're in a car, they have no information that you're dangerous, but they do know that you're armed. And we know that firearms are dangerous. I mean, of course, guns kill people. People don't kill people. So therefore, if you're armed, you are dangerous. You're both armed and dangerous. Therefore, they can frisk you. They can disarm you, get your ID, run a background check, hold you for a reasonable amount of time to make sure that you're not a convicted felon or you have warrants on you. Then they can release you. And then if you try to sue them, they can get away with it because you had a firearm, and therefore you were armed and dangerous. So that was Judge Gregory's dissent to that really bad decision, which is United States versus Robinson from 2017. Let me look back at some more of the comments here. Danny Harper, qualified immunity has nothing to do with the way they talked and treated him. Yeah, absolutely. The fact that a police officer could treat a citizen that way and not just get away with it in the courts, but not even be disciplined by the employer is absolutely outrageous. I mean, all right, even assuming that, so let's say it wasn't a civil rights violation. I mean, who else in any job can walk up to anybody, whether a citizen, or could be a competing company? I mean, anybody. When can you ever call anyone a ksucker? Not once, not twice, but 3 times, or even once. Who else? Who else is immune from consequences for that? Maybe somebody self-employed. Maybe. But what government job or what corporate job, even probably what small business job, I don't know, maybe a logger or something. But I mean, that's outrageous. So at least the court did, if you listen to the recording, they did acknowledge that this was basically that Michael was very polite and that this cop was very rude and bad. They did acknowledge that, but that's pretty obvious. Bill, the government was able to twist the narrative after the fact. Yep, absolutely. Lee, thanks for watching, or thanks for listening to the arguments. Mike, I appreciate it. Alpha, did you see the hate flyer ordeal at WVU? Call the police if you see any hate group material on campus. No, I didn't see that, but I've been pretty busy. Mike, does that include Dr. Seuss? That's a good question. So what if somebody's walking down the side of the road, with a Dr. Seuss book? I mean, what could the police do now? See. Billy, the entire concept of case law is un-American. Well, the problem is ever since Marbury versus Madison, we've had to deal with it. I don't see that changing. So while there may be a good argument as to why that's true, you don't want to hire a lawyer who's going to go into court and say that case law is un-American, therefore we should win. So, I mean, because you're going to lose. Firearms are property. If we can't own property, we're in trouble. Well, we're guaranteed life, liberty, and property. And we've had 2 of the 3, maybe even 3 of the 3, but definitely 2 of the 3 deprived of us just by executive order over and over again over the past year. Timothy, qualified immunity has everything to do with it. And that is actually, a good point here is, when they bring up qualified immunity is sort of like, giving officers the benefit of the doubt for acting in good faith, and so if they just in good faith misunderstood, and that's not the exact standard, but if they misunderstood the law, it was a mistake of law that was reasonable, because the law changes with search and seizure laws all the time, then they can be given qualified immunity. But should one be entitled to qualified immunity here when it's been the law since 2013 that you can't just stop and ID somebody in West Virginia or North Carolina for the mere possession of a firearm without more? And then he does that, and only does that, but says that he does it all the time, and then calls him a ksucker 3 times? That's not a good case for qualified immunity. I mean, that's an outrageous case for qualified immunity, if you ask me, but I'm not a judge. Klein Dean, do we have to tell a police officer in West Virginia if we're armed, for instance, during a traffic stop? No, there is no requirement in West Virginia that you have to inform the police that you are armed. And other states have state legislation that requires that, and that would be different in some cases. West Virginia, Judge Gregory goes over this in his dissent in the Robinson case, is that, look, West Virginia's legislature has affirmatively and expressly said that its citizens do not have to notify law enforcement and give over their IDs, give over their concealed carry permit, whatever. Other states might, but West Virginia doesn't. So therefore, the federal courts shouldn't create their own requirements or their own rules about what police can do and what they can't do. So we should respect the state sovereignty, respect the West Virginia legislature. So no, I guess to answer your question, no, you don't have to tell a police officer if you're armed. Now it can get more complicated depending on the circumstances. Sometimes it's another question of whether you have to identify yourself to a police officer or whether you have to give your ID. In some circumstances in West Virginia, and there's state case law on this, it could be considered obstruction for withholding your identity if there's some specific reason for the officer to know, or especially if they're investigating a felony. But that's a whole nother video. Jason, one judge referenced the 911 call, and you nailed it when you said people do that when they're scared of guns. Their irrational fear does not supersede the Fourth Amendment. So the logic is the same to say that, well, this police officer goes into a mostly black neighborhood, high crime neighborhood. There's lots of crime there. Maybe that's undisputed. And maybe he was scared for his life. He was scared for his life because it's a high crime area. And maybe he's even scared of black people. So if that's the fact, we can't just defer to that and say, okay, well, as long as he was scared, then we're going to allow it. No. If that's his fear, that is an irrational fear. That is a speculative fear. And it's not based on what he observed that's particular to this guy as to why he suspected him of committing some crime. That was, it's got to be particular to the person. It can't just be a categorical fear of a person's skin color or a categorical fear of guns or an irrational fear that, every guy he sees with a gun could be going, towards some school to shoot it up. I mean, there's schools everywhere anyways. That's like saying, all right, in the town I live in, there's a school in that direction. So nobody can go anywhere in the town, especially, well, at least not in that direction, because you're going in the direction of a school. I mean, that's outrageous. I mean, what they're looking to do is to create a radius around every school, and they're everywhere, of where if you have a firearm, I mean, the legislature has not done this. They have not said, all right, well, a mile's radius around every school is a gun-free zone. I mean, they could do that, and then we could challenge it in court and have that argument. But here you have the Putnam County Sheriff's Department asking the Fourth Circuit, after asking the Southern District of West Virginia federal court to do this judicially, to say that since he was near a school within possibly a mile, we don't even know because it wasn't in the record, within a mile of a school headed in that direction, that he can't have a firearm. Or if he does have a firearm, then he can be stopped and subjected to what happened. I mean, it's absolute. I mean, let's take the firearm out of it and insert anything else. Insert anything else, and it wouldn't happen. You could even insert a knife into this, and it wouldn't happen. This is about guns. This is about politics. This is about if they can't outlaw guns in West Virginia in the legislature because we're a red state and we have constitutional carry and everything gun related has just liberalized in the past 5 or 6 years. They're going to attack in the judiciary, and that's happening not just in West Virginia, but there's a trend of that happening where the state legislatures are granting more and more gun rights to their peasants. Gun rights are getting better in these states, and then you have the courts going the opposite direction and increasingly trying to decrease our gun rights. Save the humans. Do you surrender your rights just by entering a high crime area? That would label anything an area like that. That's exactly Judge Gregory's argument in the Black case and his dissent in the Robinson case, is that you eviscerate, in his words, the Fourth Amendment for anyone who lives in a high crime area. So you can just search anybody at any time for any generalized basis, so long as they live in a high crime area. I mean, how many people are being disenfranchised from their constitutional rights if you can do that? That's the same thing here. That's why it's almost identical to black. Anyone who lives in the vicinity of a school, or anybody who owns a firearm. And they actually, this is part of established binding legal precedent, is you can't decrease the Fourth Amendment rights of people who possess legal firearms. But yet that's exactly what they're looking on doing here. Keisha, federal law makes it a federal crime to travel within 1,000 feet of school grounds if you have a firearm in your vehicle that is not both unloaded and locked away. Well, I don't think that is exactly right. And West Virginia has legislation on when you can have a firearm in a vehicle on school grounds. But that didn't come up in this case. There was no allegation even that he was within 1,000 feet of school grounds. In fact, the only testimony was, when I asked him, was he suspected when you came up on him initially? Was he suspected of having committed any crime? No. Well, there was a 911 call. Do you know who the 911 caller is? No. Do you know what the 911 call was about, or whether it was alleged that he committed a crime? No. So what were you investigating? Well, he could have been a felon. So the only investigation you were conducting was to get his ID, to run his background check, to see in case he's a felon. Yeah. Did you have any information? Did you know who he was? No, didn't know him from Adam. Did you have any information that he had committed any crime, which obviously would include illegally possessing a firearm? No, he didn't know. He just was going to run the ID because that's what he always does. It was pretty straightforward, pretty simple. Yeah, Keisha is wrong. I believe she's wrong. I don't know what statute she's looking at, but I mean, she can send that to me and I'll look at it. But if there's a federal statute that says that would apply in this sort of circumstance, and then I'd say there should be a lot of case law on it already. Danny, and this is a good point. If he identifies as super straight, then calling him a you-know-what sucker would be an assault on gender. So why, if this guy wasn't even disciplined for what happened, then where do we apply to sign up for cancel culture? Where do we apply to submit this to the woke crowd? I mean, at the very least, isn't this offending gay people, or gay men at least, with him calling him that? Or in your question, if he identifies as super straight, then calling him that would be an assault on his gender. I think that's an interesting aspect of it. And I think now what kind of case would we have had if Michael was a gay man and he calls him that? What kind of case might we have had then? And that case, I mean, that word wasn't used, but I had a case, one of my very first federal excessive force cases out of Parkersburg, West Virginia. My client was a gay man who was called epithets related to that and beaten by law enforcement in Parkersburg, West Virginia. And he was, his father was a chief of police of a different city in West Virginia. And it was just an outrageous case. And that was a much easier case to litigate and settle. And I think had we had that fact here, then I don't think it ever would have made it this far. And that's just another unfortunate fact. Look, if Michael Walker had been A black guy, had he been a gay guy, maybe even if he had been a woman, we wouldn't be here. But this all kind of coincides with the fact that, you know, we are allowing some forms of discrimination now in this country as a matter of national policy. It's crazy. And that's not what this case was directed towards at all. It was very simple, but you know, because of the hate for the AR-15, we somehow ended up there. Mark, I missed the part of the Second Amendment that mentioned felons. That's a great point. I mean, unfortunately, there's established binding case law that the prohibitions on felons possessing firearms do not violate the Second Amendment. At least not yet. Maybe one day they will, depending on the makeup of the Supreme Court. Right now, unfortunately, the Second Amendment only extends to us having a right to have a pistol in our home. It hasn't even been extended to AR-15s. Not in federal court, at least not in the U.S. Supreme Court. Some circuit courts have extended it some. But yeah, there needs to be more Second Amendment expansion. It should apply to exactly what Michael Walker was doing that day. Unfortunately, it doesn't even come up in this kind of a case. It's unfortunately, as I've said in the past, we rely on the Fourth Amendment to white knight essentially the Second Amendment, because the Second Amendment hasn't been applied towards much of anything. We have to rely on the Fourth Amendment to protect our rights, and the Fourth Amendment has been just obliterated over the years with all this Terry stop litigation. So for people in cars, they have very few rights. Very few rights. You know, assuming that the officer is smart enough to say, you know, I pulled you over because you didn't put your blinker on, then that's pretty much it. I mean, they've met the standard of a justifiable under the law stop. So you have reasonable suspicion. But pedestrians still have some rights. And you definitely have rights in your home still. But pedestrians still have some rights. And that's why they found it so difficult, and they've had to twist themselves upside down in every which direction to try to justify this. And maybe they do just use qualified immunity, and that's just punting the issue. This issue should be decided. If they're saying that AR-15 should be treated disparately and with less Fourth Amendment protection than pistols or shotguns or bolt-action rifles, and all of that was said in the course of this case, then we need to know about it. I mean, let's put it in writing. Let's appeal it to the United States Supreme Court, see what happens there. And, you know, if they're just going to put qualified immunity, well, I thought we were going away from qualified immunity. I thought we were going to defund the police and get rid of qualified immunity. Why are we now expanding qualified immunity? So let's see. Yeah, Ed, they've turned the Bill of Rights into Swiss cheese. That's absolutely right. Laws used to be there to protect us from the government. Now it's the other way around. That's right. Let's see. All right, Michael, the sheriff of this county needs to be deposed in the next election and the individual installed. Now, I believe that the individual who was the sheriff is now out, because this isn't the only case I have against that county. It's my understanding, like if you watch my video on the drug task force cops who snuck in my client's window and all that were caught on camera, same county. It's my understanding that there's a new sheriff there. And maybe he did come in and discipline this guy finally. I don't know. I understand. I heard that he did discipline the others. Whether it's true or not, I don't know yet. But I believe that there is a new sheriff. All right. Well, Gizmo, high crime area means you're going to get violated. Last comment here, David, shall not infringe is just that. Qualified immunity is to protect corruption. Hey, I'm all for, especially if they're going to give qualified immunity in this case, I'm all for getting rid of qualified immunity, which that's nothing but legislation from the bench anyways. Qualified immunity was created by the U.S. Supreme Court. I mean, it's not even a real thing. They just created it out of nowhere, and it really does nothing. And actually, it's rarely used. It ends up applying in cases like this, just random cases where it ends up being really unjust. But in the George Floyd case, for instance, there'd be no qualified immunity there. And all these police shootings, police beatings, qualified immunity almost never applies there. It gets applied usually in search and seizure scenarios. And this is not just an innocent mistake of the law search and seizure scenario. That scenario does not involve the citizen being called a you-know-what sucker 3 times, much less whatever else happened. Ed, and yeah, then there's the gun control legislation that's about to possibly come through here with the National Gun Registry and lots of other stuff and lots of other videos that I'll have to make here. But so I'm headed to have a drink and discuss this thing with my family and make sure that they were watching. I'm going to go quiz them. But I appreciate you guys following along, and I wanted to give sort of a debriefing while it was still in my head. So I'll probably do some more writing on this, and we'll see what the court rules. I don't know what their time frame's been. Everything's different now with COVID, but usually, I mean, I would imagine it'd be a couple months at the least before they come out with a ruling in this case. But, I agreed to take it on from the beginning. Somebody asked me if I was being paid. I hadn't been paid a dime. I usually do these cases on a contingency fee. So if we win, then I get paid. But if we lose, if I lose a case, I don't get paid a dime. And Michael he didn't have to pay me anything. So no, I took this case not because I thought we'd even make a lot of money on it. I mean, what is 8 minutes with officer friendly worth? I don't know. I think it should be worth a lot, but in the end, a jury would decide what's that worth. I don't know. It doesn't even matter. It's just something that had to be done. And some fights have to be fought. And that's what and there was money offered. Money's been offered, but we've turned it down. Michael's turned it down. Not a lot, but money was offered. And to his credit, he wanted to fight this thing to the end. Now, they could have offered enough. I'm sure I would have forced them to take it. Not really. I can't do that. But, they didn't offer enough to no longer worry about that. So that's what we're doing. We're fighting it. If we lose, maybe we'll go to the Supreme Court if they'll have us. But hopefully, who knows? Maybe we win. I've been surprised before. You can't always tell. Sometimes it sounds like they're against you at the oral arguments, but they end up ruling the other way. You never know. Like the last time doing this before the West Virginia Supreme Court, I drove away from the state capitol thinking I did great. They love me. They love my client. I'm going to win. And an hour down the road, start getting calls from reporters asking for comments on the decision that ruled against us. Hadn't even read it yet. So you never know. But thanks for watching. And if you need to contact me or anything, the info's all should be there. My regular emails, jhb@johnbryanlaw.com. The website, thecivilrightslawyer.com. So thanks for watching. And Freedom is Scary was inspired, by the way, by the AR-15 style rifle, because some people think it's scary and therefore we shouldn't have the freedom to have them. So on that note, where's this one extra?
Hey, listen, people, I like to say, a million minds have a million faces to articulate. So when it's time to make your decision too, remember who it is you're fighting for, it's you. No one can tell you how you should feel inside. what the case may be.